Hello LiveLaw viewers and welcome back to our in-depth explainer series. Today we're going to spend a full 8 minutes diving into a topic that touches every car and bike owner in India. That is the E20 petrol policy. But here more importantly, we'll discuss what did the Supreme Court had to say about that. This is much more than just a news story, however. It's about India's economy, its environment, and more specifically, your vehicle. So let's start at the very beginning. What exactly is E20 petrol and why is it so important? For years, you have been filling up your vehicles with petrol. But in recent times, you might have heard about a change. That is the government's push for ethanol blending. Think of ethanol as a type of alcohol made from plants, primarily sugarcane in India. So when we talk about E20 petrol, we're basically talking about a mixture of 80% petrol and 20% ethanol, hence E20. This isn't just a random policy, however. It's a key part of a much bigger plan from the union government. And there are three main reasons behind it. First, economics. India is a major importer of crude oil. We buy billions of dollars worth of it every single year. By blending our petrol with domestically produced ethanol, we can significantly reduce our reliance on foreign oil. This saves us a massive amount of foreign exchange. Reason number two is the environment. Ethanol is considered a cleaner burning fuel compared to traditional petrol. Blending it helps reduce greenhouse gas emissions, aligning with India's global climate goals and our commitment to a cleaner environment. And reason number three being agriculture. The push for ethanol creates a huge demand for sugarcane. This directly benefits thousands of sugarcane farmers, providing them with a steady market for their crop. It's a win-win for both industry and agriculture. With the target of achieving 20% blending by 2025, the government has been rolling out this policy across the country. And this is where the recent legal battle begins. So, what's the big deal with E20? While E20 is great for the economy and the environment, not everyone was on board. The issue was a technical one. Many vehicles manufactured before 2023 were not designed to run on a fuel with such a high percentage of ethanol. You see, ethanol can be corrosive to certain plastic and rubber parts found in older engines and fuel systems. This led to a lot of concern among vehicle owners. The fear was that over time, using E20 fuel could lead to damage, increased maintenance costs, or even engine failure for their older cars and two-wheelers. It was these concerns that led to a public interest litigation being filed in the Supreme Court. The petitioners were not asking the court to scrap the E20 policy entirely. Instead, their plea was much simpler. They asked the government to provide an option, either to sell ethanol-free petrol, in other words E0, alongside the E20 blend. This, they argued, would protect older vehicles and give consumers a choice. This was a classic case of public interest versus government policy, and the Supreme Court had to weigh in. So, what was the government's defense, and what did the Supreme Court decide? When the case came up for hearing, the Supreme Court was tasked with a very specific question. Should it interfere with a government policy that has significant economic and environmental goals just because some consumers face a challenge? Representing the government, the Attorney General of India, R. Venkatramani, argued that the ethanol blending policy was a very well thought out plan. He explained that the government had considered all aspects, including the potential impact on older vehicles, and that a sudden policy reversal would create chaos and harm the interests of many, including farmers. He also pointed out that vehicle manufacturers have been manufacturing vehicles compatible with E20 for quite some time now, and the older vehicles would gradually be phased out. Ultimately, the Supreme Court was convinced by these arguments. They ruled that they would not interfere with the policy decision made by the government, especially one with such a strong basis in national interest. The court stated that unless a policy is completely arbitrary or illegal, the judiciary should not step in and halt its implementation. And with that, the PIL was dismissed. So, what does this mean for you? The E20 policy is here to stay. Supreme Court's decision solidifies the government's commitment to its E20 fuel program. And at least for the time being, there will be no separate ethanol-free petrol option at the pumps. The onus now is on vehicle owners. If you own an older vehicle, it's crucial to be aware of the fuel you're using. While the long-term effects are still a subject of debate, it's a good idea to consult your vehicle's manual or a trusted mechanic regarding E20 compatibility. This ruling is a clear message that the courts will not stand in the way of government's policies, even if it's the individual vehicle owners who end up paying for it out of their own pocket. Thank you for watching and stay with LiveLaw for more such insights into the laws that shape our lives.